trying to paint a picture that every juror comes in totally biased, like, all right, who's the local girl, who's the local guy, I'm going with him. I don't mean to give you
It's
that
like a
impression.
subconscious, like, oh, I relate to.
That's correct. It's just, it's human nature to identify with certain people. I mean, it's why, let's be frank, it's why, you know, if you have a high-profile African-American defendant like O.J. Simpson, they didn't want a jury of white people. They wanted they wanted people who were gonna like relate more to the defendant, who were gonna be more understanding of maybe his background or whatever. It's a crazy thing because it really does, in effect, it acknowledges the existence of prejudice and bias. But that is the real world. Prejudice and bias exist in this country. It exists all over the world. I mean, racism is not a problem we have taken care of, as we all know in the United States of America. We are so far from resolving that issue. And then you can start tacking on, you know, sexism and religiousism and whatever that is, religionism, and, you know, people have their freaking biases, and it's just, it's the real world. So you try to calculate for that. You try to throw that into the mix when you're making all of your strategy decisions about where to file your lawsuit, and then from the lawyer's perspective, you have to do that when you're picking the jury in a case. You know, you're looking at, you don't know these people, they just walked in off the street. When you're picking a jury, you have a little bit of information about them. You'll have a list with the jurors' names on it, their addresses. Sometimes they'll tell you what they do for a living. That's about it. So you're trying to figure out, like, who's gonna at least give my client a fair shake, you know, and who's gonna be like really predisposed to give my client nothing. There's unfortunately there are people who make gazillions of dollars teaching lawyers how to pick juries, but it is anything but science. It's more of an art form. You can get some little bit of stuff in there, your body language and all that crap, but you know, come on.
The movie The Judge does that really well. They show him
think I saw that.
The judge with Robert Downey Jr.
Okay,
And
no,
it's
I
a
have,
movie.
with his father or something, yeah.
They show him picking the juror, like asking him all kinds of questions.
Yeah,
They
I mean,
get the jurors that they need.
that's one part of court stuff that movies sometimes really kind of get right, you know, like the whole process of picking a jury, because, as I said, it's both an art and a science, but it is anything but precise. So it's a guess, and you do the best you can. Yeah.
I was just gonna say, you know, like, it could be, if you're sitting on a jury and you see a high-profile lawyer, whether it's, you know, white, black, you know,
It's
whatever.
another issue.
But
Lawyer.
I could tell you, if you're, you know, if you're of one race and the attorney is of the other race, and they're trying to make an argument, and they're just completely off the wall, obscene, you know, argument, you, as a jury, almost, and they end up dragging the case out, and you're an intelligent individual, and you know what they're saying is complete BS. You almost resent them for making that argument. So by the time the end of the case is over,
You're holding it against.
you're
the
holding it
client.
against the attorney, whether.
And oftentimes
whether-
against the client.
Whether, yeah.
Again,
And I can
we
s-
all see the world through our own personal prism, through our own personal perspective, from our own personal perspective. And our personal perspectives obviously are dictated by our experiences, our education, our upbringing, maybe your religious principles, how ethical and moral you are. All of that comes to bear when any of us has to make any kind of decision. So I'm not trying to suggest that there's always like a bad motive on the part of people on the jury. A lot of times that's not it. They think they're there, they're doing a really good job of being even-handed and giving everybody a fair shake. But even when you're mindful of that, you're still coming at the world from your own past experiences. I mean, we are all who we are, right? And you hope that, you know, throughout your life, you become a better person, you work on what we all see as our own shortcomings and stuff, but they're out there.
Plus,
And-
there's a lot of leeway. You have, you
Yeah.
know, it's not, it has to follow this straight line. The judge says, well, it could be from here to
Right.
here, and you have to decide which way you go.
That's true,
from
because the
pendulum
law
to
is
swing.
all about on a spectrum, right? The law is broad and it's generally written, we talked about that. So, yeah, there are a whole lot of practical factors that go into it. I mean, there are a lot of people that have little cottage industries out there that make a lot of money, as I said, trying to help lawyers figure out how to pick the best jury. There are a lot, like, companies like Shell and Exxon, if those guys are going to trial, they're spending millions of dollars before you go to trial, having, like, not fake, but mock juries come in. They'll set it up, you hire a company, and the company comes in, and they find people from the same geographic area that the real jury's gonna come from. And they ask them to sit in this conference room and hear all the arguments, just like it's the real trial, and then take a vote. Who have they gone for? And ask them, why did you side with Exxon in this case, or why did you side with the plaintiff in this case? And you get that feedback from them, and then, you know, the lawyers for Exxon go, okay, so these are the kinds of jurors we're looking for, these are the kinds of people we don't want on our jury. You know, civil engineer who's worked in the oil and gas industry. If I'm the plaintiff, I don't want that dude on my jury. He's gonna try to persuade everybody that Exxon's in the right, you know? I mean, it's just, it's crazy, because it's very hard to predict, but anyway. Okay, so let's kind of move along here a little bit. So any questions about the two ways you can get into federal court? All right, if I haven't mentioned this to you before, these courts, the district courts, are courts of what we call original jurisdiction. Because lawsuits originate or begin in these. These are the trial courts. This is where you file your lawsuit. This is where you're going to trial. So suits and cases originate in the district courts, therefore they are courts of original jurisdiction. These guys up here are appellate courts. So they have only appellate jurisdiction, which means they only hear cases once the case has already been decided and one of the parties, usually the losing party, sometimes both parties, want the appeal court, the next higher court, to take a look at the decision made by the jury or by the judge at the trial court. So remember that if a case is before an appellate court, so that's either going to be the federal or state circuit courts of appeal or the Supreme Courts, federal or state, the judges on the appellate court have nothing in front of them to decide whether or not the lower court got it right or wrong, except the hard, cold record. Have we talked about this? The transcript and stuff. Okay, I don't need to belabor that. Okay, so just keep that in mind. The appellate judges, they're reading everything they know about what happened in the trial court. It's because they're reading it off of a piece of paper. They don't interview witnesses. They don't talk to witnesses. They don't participate in the trial. They didn't go sit in. They didn't know the case was going to be appealed. None of that can they do. They have to make their decisions based on the written record. The pleadings, that's all of the legal papers that are filed by the parties, and the record, the transcript of everything that went on. Every word that came out of everybody's mouth during that trial is going to have been put on paper. Yeah.
Let me ask you, when they say strike from the record during a court case, does that mean that whoever the person types in actually goes in and deletes?
Yeah, you know what that means? They put in whatever it is you're trying to strike, and then they put in parentheses under it, strike that. So it's still in.
So they can't
That's like one of those stupid lawyer things. We all say it, you know, I mean, I'll fall into it, strike that. And then I think, what the hell does that mean? It doesn't mean anything. What I'm really saying is, never mind, that's not the question I want to ask you. I'm going to ask you a different question.
I mean, when the judges rule that, lawyer
Well,
says
what
something that.
the judge's job is, if the judge rules that something shall be stricken from the record, then then the jury is going, if there's a jury, if we're in a trial, the judge is then gonna instruct the jury that they may not consider that particular testimony or that document. Because the judge will say, I struck that from the record. That is not good evidence. You may not consider that. Of course, they
Right.
already heard it,
You already
didn't
heard it.
they? So they're not gonna come back and say, well, we based our decision on that stuff you told us we couldn't even consider, Judge. But once they hear it, that's why that's why you got like really super aggressive lawyers that will just say whatever it is they want the jury to hear, and the other side jumps up, objection, that's not, you can't say that. And the judge is like, yeah, you can't say that, jury, ignore that. And of course, the showman got his way, because he got to say what he wanted to say to begin with.
But for the sake of an appeal, do they actually go in and
For
redact
the sake of an appeal, they would, no, it can't be considered, because if the judge has ordered it stricken, then it's stricken. The appeals court would have to consider that didn't happen. It's part of the show that is put on for juries.
But
That's
would
really
it actually-
because judges are like, they don't care, they're not susceptible to that crap. The juries would be.
Would it actually get blacked out on the record? Or
No,
would it
it's just say that's stricken. So as the appellate court judges are reading the transcript, they'll say, oh, okay, we can't do this.
Can consider that as.
Or they can consider, if maybe that's one of the arguments on appeal, the judge shouldn't have stricken that, should have let that come in afterwards. Then they're gonna look at it and say, well, whether he should or he shouldn't. But if that's not if that's not an issue on the appeal, then they won't consider it. Question?
Have there been any attempts to try to perhaps put cameras in the courtroom? And so if something gets stricken, they actually edit the tape and remove it and then have the jury just hear the tape?
Not that I'm
anybody
aware
considered-
of. I mean, in this state, they don't allow cameras in courtrooms, other places do. California, for example, cameras in the courtroom for O.J.'s trial, cameras in the courtroom, where was that Casey Anthony?
Florida.
crazy woman, Florida. So a lot of states do allow them, but they don't edit the tape or any of that. They don't, that's not done. So it's kind of stupid. I hear what you're saying, but,
That sounds like the only
There-
way
it sounds to me-
really strike it.
well, in a way, yes, but by the same token, you're also opening a whole other can of worms. You're allowing somebody to edit a tape of what's actually going on. So like, oops, Richard Nixon, I don't know where those 18 minutes went, right? We have no explanation for that. Oh, yeah, okay, sure. 18 minutes in the middle of the tape are erased, but you don't know how that happened.
By cameras, you mean media cameras.
Well,
and
that's
not
what I was
ones
thinking.
provided by
You're talking more like closed circuit. You're talking more like recording that
I'm talking
video.
about presenting the trial in front of an empty jury box and have a camera in the jury box, and then the jury would actually see tape with all of the stuff that the judge wants stricken, actually stricken instead of the jury hearing.
Yeah, it's not a
It's a
bad
thought.
idea. It's not a bad idea. It's probably an expensive thing to play out, and
See,
never have heard anybody seriously argue, but you never know.
I see VHS actually, so. I said, I've seen courtrooms with VHS in there, so that'd be a
Yeah.
few thousand years before they do that.
So what did our comedians say? What was that?
Skype.
Skype. Yeah, it could work. Except when it doesn't. 90% of the time it's Skype, right?
They do use that though for when the judge hears.
Oh, yeah.
Yeah.
Oh, yeah. Okay, certain courts also have, we can speak of, these are all just types of jurisdiction. We can talk about exclusive jurisdiction. I think I mentioned those though. So in states that have a separate system of courts that handle only family law matters, those courts have exclusive jurisdiction over family law matters. That means none of the other courts in that state can hear those cases. Bankruptcy courts have exclusive jurisdiction. That is, they have jurisdiction over one and only one kind of case, bankruptcy. The same is true for patent and copyright cases. If you're suing on a patent in particular, there's a separate set of federal court, there's a separate federal court in DC called the Patent Court. that's where you go if you're fighting patent issues, and they can't hear any other kind of case, so they have exclusive jurisdiction over those kinds of cases. Okay, and then the last couple of points I'll make before we start talking about trials. The other two requirements that must be present in order for a court to hear a case, in addition to the court having to have jurisdiction over the subject matter and jurisdiction over the person of the defendant, courts also, where you file your lawsuit, is what we refer to as venue. So just like Howard Wolf is a venue, right, for concerts, you have to decide which court in which parish, or if you're in another state, which county, is the proper venue. So jurisdiction has to do with the authority of the court to hear the case. Venue is like, did you bring it in the right courthouse? Is this where you should bring it? But the rules kind of overlap. I'm not going to bother you with the rules. There are hundreds of venue provisions in the Louisiana Code of Civil Procedure. But for example, you can sue a person who is insured under a policy, and the insurance company is saying, well, we're not going to pay your claim. The venue laws of Louisiana say the person, the insured, can file suit in the parish where the insured lives. Okay? If it's a traffic accident case, then what parish did the accident happen in? That's the parish where you gotta go. Either there, or you can give the defendant that home court advantage. You can always sue a defendant in his home court, right? You can always sue a defendant in his home state and in his home parish. Well, we talked about why plaintiffs, you don't want to just hand them that, right? So you look for another venue. The venue is simply the location. You have to file in the right court. If you don't file in the right court, then your case can be sometimes transferred by the wrong court where you filed it to the right court, but sometimes it can also be just dismissed and thrown out. And there are rules that say if you file in the wrong venue and you filed on the last day you could possibly file because your case was getting ready to, what we call in Louisiana, prescribe, that is, you waited too long to file your suit. If you had 365 days to file your suit and you file it on the 364th day and you file it in the wrong location, by the time you figure out it's in the wrong location, you ain't going to be able to refile your suit because it's too late. So, again, all sorts of little pitfalls you have to be aware of. But for our purposes of the test, venue is just the location where the case has to be filed, where the suit has to be filed. Standing to sue is an interesting one. Standing to sue means that the plaintiff in the case has to have some interest or stake, the AKE, not the edible kind, an interest or stake in the case itself. So if we'll have a case right now where it's an adult plaintiff who is my client. He did a stint in rehab. The insurance company authorized him to go into this residential rehab program for 30 days ahead of time. He went through all the hoops he was supposed to go through. They authorized it. The bill comes. It was a 30-day residential treatment center out in Arizona. So the bill wasn't cheap, $34,500. They authorized him to do this. His policy specified that the maximum he could be charged out of pocket is $6,000, and he has to pay his deductible, and the insurance company is responsible for the rest. The insurance company is now playing hardball and saying, no, we only have to pay $1,975 So his parents helped him pay the bill. So the facility where he got treatment has already been paid. Now, he wants to be reimbursed by the insurance company, right? Because they're supposed to cover it, and they're saying, no, we're not gonna do that. So I said, I think he's the right plaintiff, the patient, the insured, under the policy. His parents want to be plaintiffs in the lawsuit too. And so the question became, where do the parents get standing to sue? What's your interest in this lawsuit? Well, as it turns out, they paid the bulk of the cost to the facility, to the rehab place. So they do have an interest in the outcome of the lawsuit, right? So standing to sue just means you can't be disconnected from the case. Like, I can't be standing on a street corner downtown and see I see a big explosion because some barge has smashed into a building on the river. I'm 15 blocks away. I'm not affected at all. I just saw it. So when the lawsuits start flying, yeah, I'm gonna file a suit too. Against whom? And for what? Just standing there, saw it happen. Where? Did I lose something as a result of that? No. Did I own the property they bashed into? What?
An emotional hit.
Yeah, well, a little remote. Yeah, if I had somebody who was killed, a family member, maybe I could try to make that argument, but I have no interest in the outcome of that suit. I have no right to file a suit against any of those guys. So one of the earliest cases in Louisiana, not earliest, but a case I usually use to illustrate this, back in the late 1960s when Congress first started passing a lot of the new modern era environmental laws, the Sierra Club, a pretty well-known environmental organization around the country, was, they would file lawsuits in all kinds of states to kind of get the ball rolling to enforce these new federal environmental laws. So they came down to Louisiana and they filed suit here against a number of chemical plants saying, you guys you're violating the new environmental laws. You're polluting the place like crazy. Their lawsuit was thrown out right from the get-go because they had no standing to bring the suit. Why? Because Sierra Club did not have a single member in the state of Louisiana. They have no chapter here, not a single member. So the argument is, who the hell are you again? Why don't y'all go back up there where you got members? You can't come into the state, because they're suing to enforce the environmental laws, saying the people of the state of Louisiana are being, screwed out of being able to enjoy this beautiful environment and these bayous and these waterways because these bad guys are throwing toxic waste into it. Well, that's fine if you, the Sierra Club, have members who are actually living here and are experiencing the inability to go and enjoy these things because of what these chemical companies are doing. So the suit got thrown out. Of course, they went away for about a month. They got a few Louisiana residents sign up with Sierra Club, right on back. Say it again?
They got one in New Orleans.
Yeah. There's chapters all over the state now. And I mean, that wasn't hard to do, right? They just went to a couple of college campuses going, okay, all you little liberals here, sign up as members of the Sierra Club. You don't even have to pay us, just sign up, right? Now they got a chapter, now they got Louisiana members, now they can sue in Louisiana courts. And that's basically standing to sue. Okay, so let's take like a 10-minute break and then come on back, and I'm gonna, hopefully we can pretty much get through the whole trial process tonight. Oh, no worries. No, just have her call me. Just have her call me. Make sure she
doesn't have too much fun.
I understand.